Serial number 1, Sumana Naganan.
I appear not for the appellant. Lord, there are three matters. I appear not in writ appeal 1006 of 23. The appellant not is the High Court Registrar Administration. The other two appeals are by certain other district judges who claim to be affected. They are not writ appeal 1162 and 1312 of 23. I find, my lord, that there is an application for impleadment that has been filed. I have no objection, my lord, for that impleadment to be allowed.
I have filed an impleading application.
These are the, who are these?
Lords, they are Lords 2017 batch, direct recruits. Learned Senior Counsel Lords appears to have no objection for allowing.
Yes. I copy could.
They have to come stricto sensu. They have to come as petitioners, and they cannot grind their axe by coming here as respondents. The difficulty is each batch of direct recruits forms a distinct class. If they have dispute regarding their seniority, they have to file independent writ petition, say that matter is covered by full bench judgment. But they cannot intrude into the full bench. Sorry, Mr. Naganan, though I am appearing in the companion appeals, and I am not, I am only a respondent in High Court's appeal. I thought I have a duty to tell the, bring to the notice of the full bench the law on the point. Law is, he is having an independent right. In somebody else's writ petition, he cannot do it.
We'll consider the application along with the main, but we'll give you audience. What we'll decide what is to be done. We'll give you audience. Let us.
One aspect, my lords, is that anyway, my lords, the objection that is sought to be raised. We are only sailing with my lords, the writ petitioners, and my lords, we have also filed objections in 2019. The persons who have come before the court, my lords, is of 2016 batch. We are, my lords, of 2017. From 2017 onwards, my lords, there is no difficulty at all. There is no issue at all. It is only up to 2017, my lords. Issue is with regard to, my lords, the direct recruits and the promote is senior.
2 of 25 filed seeking impleading in the present proceedings would be considered along with the final orders to be passed. Yes.
But Lord, as filing a third set.
As a registrar, agree.
Third set of you filed.
Lord, the respondents have to file third set of enactments and one set of case law. I will file it during the course of my argument if you are permits.
Yes.
2 sets are there on the record already.
Yes.
It is not being ready, but it may take some time.
Third set. ಇನ್ನೊಬ್ಬರು ಯಾರ್ದು ಅಪೀಲ್ ಇದೆಯಲ್ಲ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು ಹೇಳಿ ನಿಮ್ಗೆ ಯಾವತ್ತು ಹಾಕ್ತೀರಾ ಅಂತ 1312 ಪರಶುರಾಮ್ ನೀವು ಹಾಕಿದ್ದೀರಾ ಥರ್ಡ್ ಸೆಟ್
If anybody is going to start today, you can start. Because all
High
of you
Court
are
has to start, my lords,
familiar.
because
Huh?
High Court has to start because in
No,
the-
whoever, correct, our only request.
according to the petitioners, we are only beneficiaries of the High Court order. It is for the benefactor to say that the benefit conferred on us is valid and lawful. Thereafter, I can only supplement his arguments.
Now there's a divergence of opinions. Whoever wants to start can start. We will not stick to.
My lords,
Yes.
if my lords are here,
My lord, I will start, my lord. No difficulty.
Only reason is we are constituted, so we also, we have broken the other benches.
Yes,
Let's make use of the time.
My lord, this has come up, my lord, at such short notice, my lord. Honestly,
No,
it's not.
no, what we are saying is in case anybody is,
lords, it is
anybody is
better.
ready.
It is better when Mr. Naganand is ready, we start. And issue is ultimately, my lords, it boils down to this. The learned judge who dismissed the writ appeals has based his opinion on the number of vacancies according to him that were available for promotees. My respectful submission is that is a flawed view. For this reason, the vacancy, he says some of them were temporary. In respect of some of the vacancies, the notification was not issued by the government. Then, my lords, in some cases, he says it can be filled up by deputation, or therefore it is not this one. That is the first issue that has to be tackled as to what is the meaning of the cadre and what is the meaning of the cadre strength. My respectful submission offhand is that, without placing any case law, is that cadre strength can consist of not only the permanent post, but also temporary posts, deputation reserve, leave reserve, and there is also one category of posts called as shadow posts. All these 5 categories constitute cadre strength. That is the first issue as to what is the cadre strength is to be determined. Second issue would be this, my lords. Unlike the general run of rules in the state of Karnataka, which are all based on vacancy quota. They all based on 75% of the vacancies by promotion, 25% of the vacancies by direct recruitment. That will be the general run of the rules. Insofar as the district judges recruitment rule is concerned, it is post specific and not vacancy specific. This has been considered by this honorable court in 1981. I don't remember the page number. State of Karnataka versus Chikkabasavaya. Their division bench of this honorable court has explained the difference between vacancy based quota rule and another is post based quota rule. My respectful submission would be Gonal Bhimappa or VV Badami, they dealt with vacancy based quota rule. It is on the basis of VV Badami that 1976 OM was issued. And there was some aberration in between, which was set right by the Supreme Court by reversal of that aberration in Gonal Bhimappa. Therefore, reiterating 1976 OM, 1987 OM was issued. Entire discussion appears to be on 1976 and 1987 OMs, which have no application to the post-based quota. Post-based quota will have to be answered on the basis of the observations made in All India Judges Case 2, where they said that this seniority dispute has become eternal. To save it, to save these disputes, the court, henceforth, you should apply post-based quota. And it also observed that the post-based quota now, if you have to introduce, it requires amendment to the recruitment rules. Whereas in our state, no amendment was required because right from 1962, which was the first district judges recruitment rule, it has always been post-based insofar as the Karnataka is concerned. That will have to be, that cobweb has to be clear. Secondly, my lords, In quota-based rule, the post-based quota, one thing is, suppose there are two channels or two quotas. One is for direct recruitment, another is promoted. First principle, as settled in A.K. Subramanian, is merely because one channel has not been operated, other channel would not become sterile. That means once you fix a cadre strength as 100 or 200 or whatever it
Where
is,
do you find it in the report? Just see
irrespective
these 2
of
points.
whether direct recruitment takes place or promotion takes place, the day the cadre strength is fixed, the number of persons who can be promoted, number of persons who can be directly recruited, that is fixed as the percentage of that cadre strength. Therefore, operation of one source would not depend upon operation of another source. In para 20 of A.K. Subramanian, the Supreme Court has said, any such interpretation would bring sterility into the other channel, which we are not willing to, which is not the object of the recruitment. Then, what is the learned judge, while coming to the number of posts and all, apart from the fact that he ignores temporary posts and all that, that is perhaps, my lords, by a misreading of V.V. Badami, where it said cadre strength consists of only permanent posts. That is a statement made. That was on the basis of that recruitment rule. Here, total number of posts are indicated, whether it is permanent or this is all not this one. Then, my lords, another important fact that has not been gone into by the division bench is where the quota is post-based, replacement theory would operate. That is, if a promotee district judge retires, that vacancy should be filled only by another promotee. If direct recruit, the district judge retires, it will have to be filled up by direct recruitment. This is because the quota is linked to the number of posts. They get marked, though roster is not applicable here, because there is no rota inbuilt in the present recruitment rule. The replacement theory would apply. And Badami would not apply, except to the extent that if the promotions are more than 65% of the cadre strength, then only the promotee will be pushed down in the seniority list. Otherwise, kicking up and pushing down will not arise at all. And if this is kept in mind, promotees have always been less than 65% of the cadre strength. There is no question of pushing them down, irrespective of working strength. Cadre strength should be the basis to decide the quota. Then another aspect which the division bench has lost sight of or misdirected itself is this, my lords. The quota has been calculated on the basis of, even the High Court's objection statement says, High Court says that it is based on working strength. To that extent, I disagree with the High Court respectfully, and I would submit that cadre strength should be the basis. Second is, my lords, the learned judge who allowed the writ appeal, he has not applied his mind to one aspect, that is, in addition to the vacancies that arise due to increase in cadre strength, how many promotees have retired? That will have to be added to it, because replacement theory would apply. These will be the broad contours of my submissions, my lord. I cannot speak for others. This will be the broad submissions.
I have a preliminary submission regarding the view taken by the senior judge. Now, senior judge allowed the writ appeal of the High Court based on the Kerala High Court judgment. Kerala High Court judgment is concerned, my lord, there is a notification by the Kerala High Court, lord, in concern with the governor has issued, in concern with the Chief Justice of India, cadre strength means cadre strength both temporary and permanent. There is no notification in Karnataka, state of Karnataka, such notification. That too, my lord, the senior judge lost sight that the very judgment of the Kerala High Court leave is already granted by Supreme Court long back, my lord. That is not even noted in the judgment. I'll just pass over the judgment, my lord. Supreme Court leave grant.
Correct. So what we are saying that without sticking to the order,
Yes, my lord.
since we are hearing it afresh, though we have benefit of two views.
Yes.
If you are ready today, we'll hear you.
One more question is, my lord. One
I
more
frankly
important-
submit, madam, I
one
am not
more
ready
important question
to
is-
address, though broad contours I have formulated.
No, whoever's ready, let them start.
Very well.
But the first question is that the view taken by the my lord, this is, my lord, Kerala High Court judgment is concerned, it would not apply because there is no such notification state of Karnataka regarding definition of cadre tank, either by executive order or by, my lord, amending the rules. But cadre tank in state of Karnataka, Badami is concerned, Supreme Court says Rule 14 of the General Recruitment applied. Rule 14 of General Recruitment says, my lord, permanent temporary cadre also shall be taken into consideration for the purpose of, lord, cadre tanks, including cadre tanks. Whereas recruitment rules, judicial service recruitment rules says, my lord, Rule 14 would not apply at all. It excludes that Rule 5, Rule 6, 12, 13. Up to 13, general recruitment would apply. Exclusion of, my lord, Rule 14 is concerned. Rule says no, it would not apply. Therefore, cadre tank means only permanent cadre. The third question is, my lord, according to the, my lord, 314 total posts, my lord. Supreme Court says in lord, judges as such a case, my lord, 25% of the total post shall be reserved for selection grade district judge. 25% shall be reserved for super time scale district judge. Thereafter, my lord, Supreme Court, my lord, increase the, my lord, the cadre strength of the selection grade and super time scale. That is, my lord, 35 and 15. Now, State of Karnataka, in consultation of the, my lord, Chief Justice, issued an order. This is the post should be reserved for selection grade and, my lord, super time scale. I am producing that government order also. Question now is, fourth question is whether, my lord, fast track court judges are entitled seniority from the date of their appointment or from the date of their substantive appointment. These are the four questions, my lord, to be decided, my lord, by this bench, according to me.
Questions, there is no divergence. Answers only are divergent.
Answer is there, my lord. Kerala High Court judgment with the revised, my lord, it is already the Supreme Court granted leave. It can't be relied upon. And there is a Kerala High Court judgment, there is a notification, particular notification in Kerala High Court. I'll produce that order also. And recruitment rules also, Kerala Judicial Service Recruitment Rules. I will produce all the recruitment 1962 till now. I have already produced it. I have only give one more sets. And the government order recently issued by the State of Karnataka, in Chief Justice, right, which is what is the percentage should be reserved for selection grade district judge and super time case district judge, according to All India Judges case.
There is one more question that may arise in this.
These are the four questions according to me to be
Question
decided.
ಹೇಳ್ಬಿಡ್ತೀನಿ. ನೀವು ಆನ್ಸರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಈಸಿ ಆಗುತ್ತೆ. Lord, the discussion in these judgments starts from 1983 recruitment rule. And all the three persons, including the two judges of the division bench as also learned single judge, they have proceeded on the basis that there has been a quota in the 1983 rules for direct recruitment. If language of 1983 rule is seen, what it says is number of vacancies as determined by the High Court not exceeding 33 and 1/3% shall be filled by direct recruitment. Language of 1983 quota is, it does not prescribe any quota for direct recruitment. It only prescribes outer limit for direct recruitment. And within that outer limit, how many direct recruitment should be made is left to the discretion of the High Court. Therefore, on language of 1983 recruitment rule, there is no quota available to direct recruitment at all. It will have to be treated as a no rule period. Then, my lords, for the first time, quota, a definite quota in respect of direct recruitment came only in 2004 rule, where the language used is 33 and 1/3% of the posts shall be filled by direct recruitment. And that 2004 rule came into force on some date in September 2005. This language of the recruitment rule, read with judgment of the Supreme Court in High Court of Punjab versus State of Punjab, High Court, Honorable High Court of Punjab and Haryana and State of Punjab. What it said was, when you are applying a post-based quota, revised or modified quota would be applicable only from that date and limited to the number of posts increased in the cadre strength. Otherwise, what happens is, appointments made validly prior to that rule will become invalid because of the changed quota. Such an interpretation cannot be placed. Therefore, the rule will have to be applied. The revised quota will have to be applied only for increase in cadre strength from the date of that recruitment rule. If that is taken into consideration, if quota is applied only for the additions to the cadre strength from 17th or 7th September 2005, most of the direct recruits will be in excess of the quota. That also will have to be borne in mind. I will work out and place the, because as usual, files come to the senior counsel just on the previous day at 9 o'clock in the night. My instructing counsels were kind enough to give it to me at 8:30 in the night, so I could not. Broad contours I have indicated, my lords. If anybody else is ready, they can argue. But
it is post-based, it is not disputed. Facts are concerned, there is no quota, it's disputed. Right from 1962 till 83, not 33 1/3 is the direct recruitment. In 83, 30, not less than 33 1/3.
Not more than.
Not more than 33 1/3.
0
there is
to
a quota.
33 and 1/3%.
It cannot be said there is no quota. Thereafter, my lord, it is changed, not 50, 25, 25. Then, my lord, 65, my lord, 15 and 25. That is the latest quota.
Mr. Bhagwat, if you're ready.
Lord,
you
all
can-
my learned friends, my lord, are assuming that the court is fully familiar with all the facts and have jumped straight into the legal position. My lord, I'm also at a loss to understand how we can argue a case like this, my lord. We have to place basic facts before your lordship, because as your lordship rightly commented just now, what happened before the earlier bench is of no consequence. Your lordships will have to take the facts and go from stage of writ appeal hearing. So, my lord, if we go on arguing about all the cases and all that without stating the facts, my lord, it's not going to serve any purpose. It's my very respectful submission, my lord. We thought today is procedural, not because there is an application and third set is not filed. It's not fair, my lord. In my arguments, I'll have to take your lordships through the pleadings in the case, my lord, and the documents that were filed. Of course, there is a contention about the documents, how to interpret it, whether that is correct, not correct. The learned judge also, my lord, had the Honorable Division Bench had occasion to look at the High Court record also. So on the basis of all this, I have to make out my case to show why, my lord, the earlier, my lord, all these, one important fact is these four writ petitioners, my lord, who are now respondents in this appeal, they were appointed on 1/2/2016. Their main grievance is that promotions which took place prior to their appointment in the year 2014 are contrary to law. Therefore, they are saying this, since the promotion in 2015 was beyond the quota, that promotion should be interfered with, is in sum and substance what they're saying. So we have placed, my lord, from the High Court record what was the vacancy position on various dates when honorable judges were appointed? So those facts we have to place before your lordships, my lord. I don't want to, my lord, hazard an argument without all the facts being placed.
So then, which,
The lordships may give directions to complete the papers. Whoever is to file the third set, my lord, we will file. I'm appearing for appellant in my case. I will file it. And if there's any other person who wants to file, I think your lordships may kindly consider permitting them and fix a date.
now, what is the date? We have some constraints from our side insofar as some of my brother judges sitting in a bench. So
Please.
every Friday afternoon, we can take. Apart from that, in case any other day suits, you can indicate, we'll see.
Next Friday, my lord, is the 12th.
Next Friday is.
I have no objection, my lord, subject to what your lordships may feel.
Let there be clarity of who's going to start so that
High
mentally
Court
the-
will start.
I'm prepared to start.
yes.
I'm the appellant in the main case, and I'm
Now
prepared to start.
Yes.
Since vacation is advanced, it had to be fixed on 9th January, so that we can continuously go on without break.
No, let's start. We'll start.
Let us start on.
I leave it to the court.
We'll start this next Friday. We'll start. There's a request that written submissions could be filed in the beginning and at the end.
Yes.
The
We have
purpose
already
of-
filed ours, my lord.
No,
Our
correct. So
submissions, we have already
written
filed.
submission, written submissions filed at the beginning will be on the basis of what you feel, how you are going. At the end, depending on what edition, so this would also enable us to have a better idea of what each person.
Clarity and
Yes.
there will be a clear
Please.
flow of.
Yes.
We'll do it.
My opening
We'll do it.
submissions are already filed. It's
We'll do
filed
it.
on the 19th of
I
September.
will,
Since it's a fresh hearing only
Yes.
by larger bench, but we will certainly do it. The no difference.
Mat-
We'll file our written,
Matters-
not synopsis and then start our.
Yes. Matters. After hearing preliminary submissions, matters adjourned to 2:30 on
12th September, 12th December.
12th of December. All sides are at liberty to file their written submissions after serving advance copy on the other side. This would be treated to be preliminary written submissions.
Now, third judge is set to be filed, my lord. Your lordships may direct that. Third judge is set still have to be filed.
They have filed, registry has prepared and filed. If anything is left
Oh,
out,
then it's okay.
they have filed it.
Very
We
well.
check that.
The
If
registry has
anything
done
is
it,
left
not
out, you
deleted.
fix.
And only, I have to file only third set citation and government order.
If any additional sets
Registry ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ.
are to be filed, same to be filed after verifying from the registry.
Yes.
Great.